Ladies and gentlemen of the jury.
Have you reached a verdict?
Welcome to the John and Jordan on Justice podcast, your weekly deep dive into personal injury and wrongful death law.
All rise.
Touching on everything torts, legal tech, trying cases to verdict, and the outlandish stories that come with them. And now, here are your hosts, John Fischer and Jordan Redavid.
Alrighty, what's up, everybody? Episode 14. You've got John Fischer, Jordan Redavid, Fischer Redavid here back to talk about some things that are kind of on our minds. What's going on? No guest today. Just kind of me and Jordan giving us our thoughts on some things as we go forward. So
back to basics. Back to the original two.
Yeah, back to what we do on a normal daily basis between ourselves.
Yeah, and sometimes life has a way of giving us topics to talk about. I think today is one of those. And I think we could, in an overgeneralized way, maybe just cabin it as dealing with tough judges, challenging judges, and maybe give some anecdotal experience and also maybe some tips on how to do that in a variety of situations.
Yeah, I think that, generally, like, no human being is the same. I feel like a judge is like a fingerprint, right? They're never the same. You've got different dispositions, different age groups, different backgrounds, different jurisdictions. I mean, everything is completely unique, and it's kind of a blended bag. And sometimes those judges can be difficult, tough, obnoxious, condescending, and sometimes unnecessarily. So, kind of what I want to talk about is how do you deal with that in that situation? I had a hearing that recently on a very minor issue. Now that we're in Florida, there's like this mandatory thing of like, you don't get continuances, you don't get extra time. COVID's your fault as lawyers and plaintiffs or defendants, and like that's it. We're going to trial and everything. And so we got a case management order in a case that was requiring expert disclosures before I even had an answer from one of the defendants. It was like a complicated products liability case. So I went in and said, look, these deadlines that have been established by the court unilaterally, it's a case management order, then, something new to the state court level, or at least in personal injury game. And they extended it out. We really want to say, look, the case isn't at issue. We couldn't even set it for trial. Like, let's extend these deadlines. That was it, like 60 days, right? Something minor. Went in, and at the start of the hearing, the judge, even though, because it was unopposed and all those things, said, which one of you wants to grovel? I mean, that's a direct quote. And it's not necessary, right? Like that, like it shouldn't be like when I'm seeking relief from the court. It's not, I shouldn't be groveling to get relief on something.
And just to clarify, man, any prior experiences with this particular judge that you feel like there was harbored ill will? Because I don't think so, right? I mean, this was just kind of coming in cold on a routine issue.
That's how the judge is. He's very tough, and he speaks his mind, and so it's not a ill will towards us or the plaintiff side or anything, but he can be very challenging. And so, how'd
you deal with it? What'd you say, or what did the other side say?
I mean, basically, I just said, well, I guess that'll be me, Judge, right? That's kind of like, would you like me to present my position? I presented the position, and as you can imagine, it was denied. So, what I've tried to do with difficult judges is like recognize that, like, look, the law isn't going to change, right? A judge's ruling on that law can change, but obviously, if you're establishing and giving good law, taking good positions, and kind of maintaining that, and there's an adverse ruling and something that obviously you don't want to think about this, but you may be able to address that in an appellate capacity. But you want to just keep doing what you're doing the right way. Don't get, like a personal effect from it. At least not in the same setting. Afterwards, obviously we can, piss and moan about what the judge did. But in terms of that, just say, look, like, recognize it, make your position, move on, and then obviously if it goes your way or not. And what I've found is even, especially back to trial stuff, is when you have a sidebar, even when you lose or have a tough position sidebar, smile, leave like you won. You know what I mean? Because the jury's not really understanding what's happening, and they may not know. So it's those kind of things.
Yeah, during trial, you may want to keep a game face on for the jurors, but it's just a routine hearing where it's just you, the lawyer representing the opponent, and the judge. It's hard to do at some point. There are limits. We're all human beings. We all have certain thresholds, And I mean, for me, I wasn't there for that hearing, but it begs the question for me, is such a comment really ever appropriate from the bench? Even if in jest. And I feel like the answer is no. It just should never, something like that should never be tossed out. Much the same like we hear some judges say, hope you brought your checkbook, foreshadowing sanctions. It's not really an appropriate comment in my personal belief.
Yeah, I think I agree with you. I mean, look, as us as lawyers, obviously what we say to the court matters, and I think it should matter backwards. And and not to say that, I mean, look, there's great judges, and not to say that this judge is a particularly bad judge. He's not. It's just, that's the way that he operates. And so we just, looking at it of what can I do to try to make it better, and the answer is you can't really do anything. I mean, it's kind of the luck of the draw. It's like anything. I mean, it depends on the form you're in. It depends on the judge that you have, and sometimes it can affect a case, and so.
Well, yeah, and that's the point is you don't want it to affect the case. It shouldn't affect the case, right? In theory, we don't live in theory, but in theory, it shouldn't matter who the judge is who presides over a case. It really shouldn't. But I think, when we step back from this topic, it's like, let's answer maybe the preliminary question, which is like, well, what is a tough judge? Because that can mean a lot of things. And I've experienced it personally in a lot of different ways. A tough judge might be a very fair one, but maybe he or she is tough on decorum, punctuality, wearing the appropriate clothing, sitting in the appropriate places in the courtroom, right? Or maybe not bringing a beverage to counsel table, things that I'm not going to call them trivial, but they're less substantive. That could be a tough judge. Sometimes just the environment. A judge could be tough on, it feels like one side versus the other. That doesn't do anybody justice. A judge could be tough in terms of, and I think we've both experienced this. Sometimes they're kind of open about, look, I'm so busy, I haven't had a chance to read the briefs. What's that issue here? Kind of catch me up to speed. And it's like, that's tough because I just poured maybe 4 or 6 hours into this motion or response, and I was hoping you would have a chance to read it. Or maybe the judge is just tough because it's hard to get a point across. Sometimes you perceive that they have a preconceived notion on how a particular issue should be resolved, and they're not really receptive, it feels like. And any one of these things, obviously a combination of these things, present a series of challenges when at the end of the day, you're trying to win for your client within the confines of the law. And I'll say that because we're all people, I've never been a judge. I don't know what it's like to wake up and put on a black robe, and I hope to never. But I do know what it's like to wake up and have a hearing to look forward to, and you can anticipate getting friction from the lawyer on the other side. I've never been in the judge's, position to maybe they look at hearings and they say, oh, these two lawyers again, right? Or these two sides or these two law firms. Maybe they dread a hearing sometimes because they're not looking forward to it and that bleeds through. So I can understand there's a human element to that. But one of the things that I wish, and I think it's aspirational and will likely never be attained in the laws, I wish there was a little bit more clarity, more black and white on some substantive, procedural and like evidentiary type issues that tightened up the discretion for trial judges in particular to kind of rule on a whim and leave either side who's unhappy with the ruling in a position where, sure, can you theoretically appeal it at a future date? Yes. Is it likely to get disturbed on appeal? No. And because at least in Florida, judicial decisions that are left to discretion are so widely protected, it feels at times near impossible to get it overturned, even when everyone kind of accepts that it was the wrong ruling. That can make a very tough judge, a judge who knows how to wield his or her discretion in a way where they're not likely to be overturned, but they can disrupt proceedings.
Yeah, and I think also, and you might have mentioned this, was those judges that are like sticklers for the rules and deadlines. They're like, you don't get more time. This is it. I mean, that's what we get. Federal court, to a degree, they allow sometimes, but, for the most part, that's it. These are the deadlines.
Well, we're all trying to do our best to manage our caseloads, judges included, obviously. They're not immune from those pressures, and frankly, they probably have it more than most plaintiffs' lawyers, definitely us. We don't have a huge caseload. But there's a balance to that, right? We want to be respectful of every party to the process's rights to prepare their case and then have it heard. But that inherently breeds, it breeds opportunity for there to be some conflict. And I don't mean that in like a very aggressive sense, just a natural scheduling, whatever. You share experience. I've had other experiences that I would characterize as with tough judges that they stay with me for years because I go to sleep at night even still. I can't understand them. So like one example, a real life example is I once brought a constitutional challenge to a statute that was originally written or at least spearheaded by this particular judge before he took the bench when he was a state legislator. So you've got a former bill drafted by, in large part, this person. Clearly they believe in it and its language being constitutional, obviously assuming the best here. I think that's easy to give. Then years later, he is put on the bench. There's a challenge to that same now statute's constitutionality. He's presiding and, cutting to the chase here. I filed a motion. I just said, look, I don't think of all the jurists in the state, you're in the best position to be fair and neutral on this particular issue. And I gave the very straightforward reasons, and he denied the motion and said, no, I could sit and preside. And at the hearing, I remember making a comment like, this is perhaps a poor analogy, but at the time, this is what I said. It was basically like asking him to decide if he liked his children or not, or, it just didn't seem right. He denied it. I took an immediate appeal and the appellate court denied it too. Under the notion that I believe that if we go through this idea that if you were once a part of the state legislature and then you go on the bench, then you kind of have to be screened out of cases. It could really complicate the judicial assignment. And I see that, but it doesn't come up all that often. Right. And I thought that one was really tough because I don't think our client got a fair shake on a really important legal issue that really had a cascading effect on how the rest of that case played out. And, that's something that like sticks with me for years because it's like I try and put the shoe on the other foot, so to speak. And I'm like, I would never personally stay on that issue. I would probably voluntarily get me out of here as fast as I can. This is just not the issue for me. But, so those kinds of things happen. And I guess the issue for us today is not to just sit here and gripe and complain. That's really not the intent. It's really to say, how do you deal with it? Yeah. And in that particular case, just like many others, you have to keep putting your feet forward and walking down that path. At the end of the day, your clients hire you for a reason. They don't hire you because they're hoping you get a particular judge or you end up in a particular venue with a lawyer on the other side. They don't care about any of that. They place their faith in you to get them justice. And so obviously the defendant is usually standing in the way of that. And I don't think any judge ever purposely is standing in the way of that, but sometimes rulings have as a byproduct of rulings, they stand in the way of that. And you have to still nevertheless navigate to that finish line because blowing up the case doesn't do anything for you as the lawyer and it only hurts your client. So you've really got to be able to, as John kind of said earlier, keep that game face on, swallow and keep going, swallow the bitter pill and keep going.
Yeah. I mean, you can't do anything about it. Right. And if you allow it to affect it, then, you won't be you'll be doing a disservice to your client. And what I've found is that sometimes those tough judges, that can become because of the product that you're doing and you continue to do it and you've challenged them and in a context of the rulings can then turn out to say like, well, hey, these guys are doing it right. Maybe I should be listening to them. And that can kind of be a good effect moving forward. So, we've seen both sides of that.
I mean, the last thing I'll say on tough judges is sometimes there's a silver lining. I started my career assigned, as an assistant public defender, you get assigned to a judge's courtroom. So you handle all the indigent clients that come through there that need the office's services. And it was one of the greatest jobs I ever had. But as a result of that, you don't have no choice. So you're in front of the same judge every day in, day out. Your clients change, the judge never does. And so if that judge is tough, like I started my career in front of Fred Serafin, I think he's tough in that kind of that first camp I was talking about, expectations, decorum, professionalism, punctuality, all reasonable things for him to expect. I didn't have all that out of the gate. I had a couple oversized suits from Men's Warehouse, sweating my ass off, trying to grind through a bunch of these cases and help these clients. And sometimes when you're wheeling and dealing with the state, or you're trying to take an interview of a cop in the hallway, think about the legal issue, run up to the law library, it's hard to be punctual. It's hard to dress professionally. It's hard to always kind of have that professional appearance. And, he used to let me have it pretty good, but ultimately, and not with the benefit of too long of hindsight, he made me a better lawyer because The pressures, I think, in that particular courtroom that he put on me, I feel like helped shape me into a bit of more of a diamond as opposed to just a shitty piece of coal, which is probably how I started my career. So there can be a silver lining there. And I owe judges like him a debt of gratitude, because that's tough for the right reasons. I think that's tough to make sure that the people are practicing to the best of their ability before you and taking the whole proceedings as serious as they need to be, you know?
And I think there's value to what you just said, that, tough judges can make you better. And I think it's true, because if everything was easy, it's always that, if everything was easy, there wouldn't be good judges. What's that saying? It's like, good times make soft men make bad times, and then bad times make hard men, and I should say people, not men, and then make good times. And so I think the same as when you have it difficult and you're practicing difficult, it makes you a better lawyer. I started, my first primary practice was in federal court. And so federal court has very rigorous expectations. Deadlines are very strictly enforced, very specific, like rule-based. So it made me be very rule-based, respecting deadlines. So when that came to state court, where I used to refer to it as the wild, wild west, where everything was just like, pew, pew, we're just shooting from the hip. I take a very structured, rule-based approach and deadlines, and I have used those advantageously, in state court against opposing counsel based upon various things. So, I think there's value to that, is that take the tough time to make yourself a better lawyer, and then, it'll still be tough, but, you can deal and plan with it and kind of, adjust accordingly.
Yeah, we're talking about tough judges, and maybe it's a good time that it's kind of a related topic, but it's the summer, tailing towards the end of it. At least my kids start school back again mid-August. Just got to spend some time with the family at the lake for 4th of July, which was nice. But the summer has a way of often, not always, slowing down a little bit, at least in the litigation side of our business historically. And when things slow down, it gives you time to reflect. And when you reflect, it gives you time to really think about a lot of things you don't otherwise have the opportunity to. And one of the things I find I constantly keep getting my mind back to is, how do I stay motivated? Not just an individual case. That's easy. Client signs up. I'm excited to take the case. We take the case. If an issue comes up or we need to press it, that's easy to be motivated about. But I'm talking motivated on a larger scale. How do I stay motivated hungry to learn more independently as a lawyer so that I could be a better lawyer? Whether it's CLEs or meeting with people. How do I stay hungry to grow the business, meeting other lawyers or finding other marketing opportunities? How do I stay hungry to be a better manager of people, right? We have all these human beings working with us on a team. And for me, especially being remote, it presents unique challenges, but how do I stay motivated to do all that? So, and the list goes on, but I think it's good when time does slow down to reinvest yourself, in your business, and all that. I don't know, John, do you have any thoughts on that?
I do, a little bit, and I find it challenging to stay motivated, and not for the variety of things that you said, but just because the practice of law can be exhausting, right? In the sense that it's a lot of times it's the same fights on the same issues with the same people and the same experts, and it's like, look, like obviously this is the game, and I'm going to call it a game because that's what it is that we play. We're just moving around the chess piece in a different variety. That to me is what sucks out my motivation to be even want to be a lawyer at sometimes. Like, right? Like I have those moments where I've been a lawyer for 10 years now, and I'm like, it's about 10 years too long sometimes. That's how I feel. I should have done something different. Maybe I could have been, some other kind of business owner. And not to say that, look, I feel like I provide tremendous value for my clients, partnering with you, like we have a great thing going, but it's a lot. It's a lot. And so, I see these things, and I think what really is giving me challenge right now is the idea that, like, I got a 4-year-old and a 2-year-old, and they see that video that goes around on social media about the age of 0 to 5 is the most important time for their life, and it's like, am I missing it? Am I missing it because I feel either subconsciously or directly that I have to be working, or I need to be here, or this has to be done? And so, for me, it becomes mentally difficult to say like, look, I'm going to take a vacation. And I said it today. I was like, I need to go do something. I want to take my wife. We're going to go, and we're going to go home, see family. But I never disconnect. Like, I never disconnect. I never am said like, I'm just unavailable. And I don't think I can ever be.
Well, it sounds to me like, you're motivated in two ways. Cause I mean, two observations as somebody who gets to be around you and interact with you on a regular basis. As a professional, I share all the same sentiments. I really do. Coming up on a decade of practice is a tremendous accomplishment. At the same time, it gives you what feels like a full career to look back on and say, how many times have I run through this same hamster wheel here on the same issue with the same expert, whatever. But by the same token, having 10 years now, you undoubtedly are able to be more efficient and have less stress managing some of those same issues that come up. And it also provides you with the experience where we were just talking the other day. You're likely board eligible to become board certified as a civil trial lawyer, or if not, you're on the precipice of it. And what a tremendous accomplishment that would be if you elect to go that route.
Right.
And because that's something that 1% or less than the Florida bar of members of the Florida bar is even eligible for. Right. So tremendous accomplishment. That's not something you just practice a decade, you're eligible. You got to work your ass off to get there with all the trial experience and the like that you need. And you don't get that just sitting at a desk pushing papers. So that's something that you should really, that I hope would continue to motivate you, because it's something you should be proud of for sure. But on the personal side, I also share the same sentiments, because it sounds like you're also just as motivated to be the best John Fischer you can be. Like, I'm, motivated to be the best Jordan I can be. I mean, I want to be the best husband, father, whatever. How do you do all those things if you're handcuffed to a business, to a law firm, to a client, to a case, to an issue, to a hearing, to a trial calendar that you brought up where we're talking off the air? I mean, our trial calendars, it feels like just throw out the scroll and pick a week. We're on it. That's what it feels like. And when your calendar looks like that, scheduling wise, how do you take time to reprioritize your family? It's not often easy to do,
It's hard. And obviously, because I feel like, I post on TikTok now, so I watch a lot of the trending videos of what's going on. But there's a video that says, I didn't want to work a 9-to-5 business, or a 9-to-5 job, so I started a business, and now I work 24/7. And I'm like, and sometimes it feels that way, right? Because and obviously, look, like, I don't want to suggest that I work all the time. I don't. I mean, I take time off. This actually July 4th weekend was the first time I had friends in town. I got to and I did disconnect, and it felt great. And then I'm coming back the next day, be like, all right, what has happened? Hopefully nothing. But, having that ability to separate myself from work and really try to enjoy life, because I don't want to say, well, what happened? Well, I worked to enjoy life at 65. Like, I just, that to me is not what I want to do. But at the same time, I want to be a great trial lawyer. I hope and have aspirations to be one of the top trial lawyers in the country. And what do? I try to learn from them people. I see what they're doing. I try different things. I read books, but now I'm finding time to say, like, do I even have time to read those books and to go to the seminars and go to the things that I need to do while trying to try cases? I mean, we're set. We may have 5 trials in the next 6 weeks. We're talking all over, like Seminole County. So I think we got one in Sumter County, Dade, Broward. I mean, and these are cases that are set 17, 18, like, they're going to go. And so it's like, how do I say, okay, right now I've got a lull, right? I've got this doubt. We had a case settle next month, and I want to take time to go do something. But how do I do that when I've got 5 trials in coming up in the month of September, like starting in August into September? How do I do that? And that's what I find when I'm staying motivated, when sometimes it's like trying to find that way, because then I'm like, okay, well then when am I going to find the time to take off? All right, I'm going to do it in October. Well, what happens in October? I got another big trial, 2 trials in November. And that's so for me, staying motivated, it's not really like I look at like there's an end game, because there's not an end game for us, right? The end game is said, look.
No, but John, in fairness, I mean, you're a runner, even though you run outside for 10 miles at a clip or whatever you're doing. I mean, if you had a treadmill and you wanted to be fit, you wouldn't, you could turn it on and just leave it. And anytime you want to step on it and run, but you wouldn't stay on there forever. So I think, find the time to refuel the tank, especially now during the summer, or a case just settled, that we were about to try in August. You have that window. I don't care if it's 3-4 days, just take it, because, the work's always going to be there. And so and then by that token, because you're motivated to be present for the family, you'll take that time, you'll come back. I think you'll be re-inspired, re-motivated for the work that you're going to have to do anyway, which you'll do a great job at. So just take it. We got a great team of people. And I think, for anybody out there that feels that way, if you have the ability to take the time, just take it, because you can't get it back, like you said.
Always going to be there. It's not going anywhere. And I think that you're right, is like just taking a moment to step back and understand, like, it's sometimes like when you step away, you become reinvigorated to come back and crush, right? Like I've had
100%
conversations with you where, I've come in, I've had a couple days off, and I'm like, I'm ready to drop the hammer. I'm ready to come in here and spit hot fire, and I'm filing motions, and I'm setting depots, and no lie. After this podcast is over, 3 minutes afterwards, I'm taking an expert depot. I'm ready. I've been ready, and I'm looking forward to it. It's a guy I just crushed 2 weeks ago in the case that's...
I'm sure he's excited.
Well, so it's like, some of those things of... because I like competition. So for me, being motivated is like, I like to win. And I think when in our business as the plaintiff side, we have to win, right? I don't make money unless we win. If we don't win, we don't survive. So it's like we have to win in order to eat, in order to provide, so that's my motivation, is really like, I want to win. I think that drives me, my competitive spirit, obviously in not in a negative, like I'm going to burn your house down kind of way. But my motivation of like, you're a worthy opponent and I'm going to win, and I'm going to win with what I have, the tools that I've been provided, and it kind of like establishes yourself like, okay, we went to trial, I beat one of the best, and, that reinvigorates me for the next case. Like maybe I am the one that can get to that level, seeing with what I do. So those are kind of some of the things that I can think about.
Well, I was, you were part of it yesterday, but we were part of an 8-hour mediation, and, due to mediation being confidential and all that, I'm not going to get into the particulars, but the duration of it is not. I went to sleep last night. I woke up this morning, and one of the things that keeps coming back to my brain is like, holy shit, man. I spent 8 hours in some organized, forced, awkward conference to try and settle the case because I had no choice to. Because, I have a duty to my client to be there and give it its best shot, and the other side does too. But it's like, is this just one of the other things that's like death of a trial lawyer? This whole forced arbitration, forced mediation. You should remediate. Did you mediate? You know what? Try it again. It's like whatever happened to just one side picks up the phone and calls the other and says, look, this is what I think the case is worth. This is what I have. Is that enough? No. All right. Is it ever going to be enough? No. Am I close enough? No, you're not. Are we trying this thing? Yes, we are. All right. And then both sides prep the case for trial. I'm not saying that kind of thing never happens, and I don't want to oversimplify the complexities of litigation, but I can't help but feel like as my career has gone on, I feel like more and more it's like people watch movies. We were talking about this off the air, right? What legal movies are accurate or inaccurate, but it's like most of those movies take place in a courtroom, where trials happen 2 days after the liability event happens or something, which is also unrealistic. But I would love to be back in a courtroom all the time, like I was in my public defender days, just day in, day out, trying cases. It feels like every other week. And man, oh man, I just feel like in the civil side, it's just getting exceedingly hard to find your way into courtrooms. I'm grateful to be able to have tried the one we did recently and all that. And I guess if we get 4 or 5 a year, we're doing great. But it's like, I feel like we should be able to try 15 to 20 cases a year. And I just feel like it's impossible. And so I don't know if it's the system, it's the people in it, it's just a general desire from everybody else not to want to try cases because it's too time consuming. I don't know what it is, but I can tell you it's frustrating at this stage of my career when I feel like I don't have access to try a case as readily as I want to,
Yeah, I think that, that statistic, it's like less than 2% of cases go to trial, right? Or something exceedingly low. I think that in our office, it's much higher than that, right? I feel like
I was keeping track for a while. I stopped, but it is higher significantly.
I think ours is much higher than that. And look, a lot of the cases that don't go to trial may be in a situation that the insurance company or the defendant carrier does the right thing and pays money. They pay fair, reasonable value for the case. Now, if they're not paying it, or if you got a really good case, you should go to trial. And I was watching, Rex Parrish, he's a big trial lawyer out of California. He just put on his trial school I don't know if it was trial school, it was trial something, but I was unable to attend, but I got the on-demand thing. And in his opening remarks, he was talking about how do you get, he got a $56 million verdict in a case. And he was like, well, how do you get $56 million? You know how you do it? You reject a $20 million settlement offer. Rejected. You know?
Yeah, and who's doing that, by the way?
I mean,
is.
Can I say that I would be in that same situation and turn down a $20 million demand? I would like to think so, but maybe not. You know?
No, but it's economies of scale. So, or maybe that's the wrong phrase, but it's an issue of scale, because just taper it down to something more realistic, at least in our woods. It's like, are people turning down the $200,000 offer when they know it's a $2 million case? Are they turning down the $1 million tender when they know they could probably get 5 to 10 at trial? So it does have the same effect. It's interesting that he started that way, because I do think that's the starting point, because ultimately we're in control, meaning it's up to our clients whether to accept or reject. But that's where, like, I have long said, criminal or civil, it's all the same. I think the most influence we have as lawyers is counseling our clients to accept or reject a deal, a plea deal or a settlement or whatever it is.
Yeah.
And that's part of it.
Yeah. Well, I mean, and I think part of it is because for many plaintiffs' lawyers, including myself, have we been in a situation where we think about like, oh man, there's a good offer on the table. Like, my fee is going to be like $100,000. If I go to trial and get zipped, I'm getting zero. That's a real life thing. Like, and not to say that, a plaintiff's lawyer or anybody is putting their interest above that of the client, but that's in back of the mind, you're thinking about that, right? Like, oh man, this case sucks. Not sucks. I don't think sucks is the bad word. This is a difficult case. It's got questionable liability, or those cases where I think I can get $5 million at trial. They're offering me $800,000, and you turn it down. And then you go to trial and you may be successful. What happens if you go to trial and you lose? He was saying he's turned down $10 million offers going to trial and gotten zero. He's like, I got a lot of explaining to do. And so, I feel like that idea of that confidence that you can make a difference and go to trial and win. And we did that in, I know I talked about it before, but we did that in the Marsh Gonzalez case, as we said, look, we can win. And they're offering $750,000, and we're saying, no, thank you. We're going to get better at trial, and we did, because we were confident in what we had. And when you have that confidence, you can say no. You can say no. I don't, we have, kind of this idea that, all these ADR, these alternative dispute resolution techniques are great. And look, I don't want to say that mediation as a whole is bad, because mediation, I think, can be good. I mean, we've been a part of very fruitful mediations where we've done significant presentations and kind of laid it all out, and it was wet. But I've been in ones where
No, it's the forced component. Every one of these tools has value for the right case. It really can be fruitful. I'm just saying it's the idea that we treat it like this assembly line where every case at some point rubber stamp it with mediation. That didn't work. Maybe rubber stamp it with non-binding arbitration. Right. It's like, well, wait a minute,
And that's why it's just another aspect of big business for somebody to make money. Like, it should be, I don't need to sit with someone to tell me how to value my case. Really, to me, mediation is never for the plaintiff. Mediation is for the defense.
I agree. And I tend to see them wanting it more than we do. Remember we had a period of time we were following all these motions to dispense with the orders referring us, but they kept getting denied. So, at some point you just...
The case that we just settled.
No, but I mean, generally, judges want you to go because they want the case to go away too. So, but yeah, I think it's generally something more that the defense wants. Maybe it's because it puts the insurer or the agent for the insurer, like the adjuster, and the defense lawyer in the same room, probably for the first time.
Maybe from us. Maybe they get to be with us and they get to hear it directly from our mouths. Maybe that's why it's advantageous. But I just think that it should be where if the starting premise is that there should be no roadblocks to going to trial. Zero. If a client doesn't have money to go to mediation, they got to be paid and forced to go to mediation. They got to pay for it. It's not free, So they have to
definitely not free. Not free, not cheap.
Not free and not cheap.
For what it is.
They have to incur that expense to go to trial. That doesn't seem right. There should be no encumbrances towards our ability to go to trial. And then now we've got this thing where you have mandatory arbitration. We have to go to an arbitrator. And look, myself and Jordan have been part of an arbitration. It's a joke. There are no real rules. There's no evidence is lax. You're just like, people are just arguing.
You took the words out of my mouth. Often the law talks about it being a lax proceeding. It's like, well, that's not what I want. It's definitely not what my client wants. I don't want to call it make believe. It's not. It's a very real thing. But it's like, no, they want at any time. Listen, anytime I need to stand up and be an advocate for my client, just like you, I want to put on my best foot forward. I don't want to be lax. I don't want to give you a proffer of what the expert says. I want you to hear it from her mouth. I don't want to give you a proffer of what cool, compelling demonstratives I'm going to show the jury. I want to show them, well, I don't want to go spend 20 grand to get that made yet because it's not trial. It's just,
right.
It handcuffs you and your ability. And
here's the problem. Here's the problem with arbitration and with mediation that's not present with the jury. A jury does not have to curry favor with any side in the case. Any side. An arbitrator has to be selected. So what do? Well, I don't want to hammer these guys too much. They may never want to use me again. This is business for me. Mediator, same thing. Well, he was awfully tough on us. I don't want to do that. He was giving too much for the plaintiff or the defendant. So, they got to play this like in between instead of doing like recognizing what it is. So I believe that a jury is the best way to resolve every dispute. I believe that. And you're never going to tell me otherwise. You're never going to say like, oh, the mediation is the best. Now, look. People like mediation. They do good jobs at mediation. I used to care more about mediation. I don't anymore. I don't even really, yes, I want to see their case but you're not going to necessarily see mine because I don't look at it coming in every time like it's going to settle the case because like Jordan said, you can pick up the phone and you could call me and we can talk about resolving a case. I don't need to spend $3,000 to settle a case,
We did that. I did that recently on a case. I was just so happy that the other lawyer was open to it because it basically went something like this. The other side reached out. The case had been going on for a while. Hey, but this might be a good time to mediate. My side's. I wrote back, just give me a call with a number when you're ready. I'll relay it to my client. I'll call you back and say, yes, we accept, or no, here's another number. He did it to his credit. And in like 2 phone calls, it got done. And everybody saved about $1,800 aside in mediation costs. And God knows how much time scheduling and waiting. And I think both clients, which is what matters, were much happier for it. So I think that should be the norm. And I'm totally with you on the big disputes, meaning like the actual controversy of the lawsuit, that should be resolved by jurors because in that scenario, both sides are dealing with the same captive audience of jurors. People plucked from the community largely against their will. Seriously, nobody really wanting to be there, or very few. It's a civic duty to be taken seriously. And I don't want to discourage anyone from doing it. It's the opposite, in fact. But I mean, they don't want to be there. They're being disrupted from their lives. Unlike a mediator or an arbitrator who's being paid to be there, a juror is never going to see you again. They'll never sit on another case. They'd be disqualified, right? An arbitrator, mediator almost necessarily wants to see you again, both sides. Right. So there are these things that are not the same from a decision-making standpoint that allow the controversy, in my opinion, to get resolved the right way all the time. And I think at the end of the day, it's just like, I just go to trial, man. Just let us go to trial. We've all had the cases where we've gone, think we're going to win and we lose. We've all had the ones we're not sure about. We go hit it out of the park and everything in between. It's not that predictable, but the reality is it's the best solution to solving controversies. I'll never be convinced otherwise, just the same as you. So that's why I get so frustrated when I see all these impediments or encumbrances, as you said, to getting there. It's also why I get frustrated. And by the way, there are so many great lawyers out there on both sides of the fence, but I know more plaintiffs just by, the nature of the beast who still try cases, want to try cases. So this is by no means saying we're doing something so different that no one else does, but the numbers speak for themselves. Clearly we're in the minority here, no matter what other people actually say, because the numbers don't lie. If 2% or less of cases are going to trial, 97% of cases are being settled. So we got to fix that, I think, by and large. And because when people are settling cases, we talked about this with Joe Freed. I don't want to beat a dead horse, but how many times are they trying to jam confidentiality down your throat so the world doesn't know? That's another part of a trial. A verdict is public record, all the way around, no hiding. So I just feel like there's just a tremendous benefit to trial that is lost when cases settle along the way. And I think most cases settle along the way because the client runs out of patience or they get frustrated or the lawyer does, whatever it is. And it just kind of runs out of steam. And I don't think that's the way it should be. And I wish there was a better allocation of resources to have more courtrooms, more judges, pay these jurors better money so that they're not, I mean, how many times has there been a ideal juror? And I don't mean pro plaintiff, just somebody who seems like they're attentive, they're educated to listen, they can decipher bullshit from truth. They can miss their work, obviously, right? With that. But like there's a childcare issue or there's a concern with this because they're getting whatever the hell they're getting, crumbs per diem. It's like, it's not fair either. So the system is not set up for success. Definitely needs a large overhaul, which is why I complain about it, but you take action and you're on rules committees and the like.
Well, I think, look, I try to be on the things that it will affect my practice. If it's the rules committee, if it's the evidence committee, I didn't even know there was a committee for the jury instructions, which I would have loved to be on to have my input in that. But the thing is that being a trial lawyer, that there's inherent benefits, not with just like, hey, we need to go to try a case. I think when you are a trial lawyer, we file every single case like it is going to trial. The way we litigate our cases is like they are going to trial. We don't litigate cases to settle them. And so if you got the idea like, oh, we're going to file, they're going to pay us more money or not, no, you need to file with the idea that they have to pay you to stop you from going to trial, right? You're not filing to get them to pay you money so you can settle. They need to pay you to stop you from going to trial, right?
Yep. Two of our biggest settlements as a firm, or I think they are, definitely one of them. But years later, they still stick with me. I don't want to say regret of settling. It's not a regret, but the frustration of not ever being able to try those cases. So like, this is not about, I want to try cases because to me, it's the only way you can get big numbers. I'm talking about multi-million-dollar, 8-figure settlement. It still haunts me at night that I never got to try that case. And it's not an isolated outlier. That's how badly I want to be trying cases. And I hope we do a good enough job conveying that to clients. I think we do, which is why when it comes time for them to select our firm, they do so knowing full well that we're going to work that thing up, just like you said, and press it to the limits. And we're not doing it in hopes to pressure them to settle. If they do along the way and it makes our clients happy, then, hey, we've done our job. But we're doing it because we're hoping one day those floodgates open and we get to go fight in the Coliseum for our client, And
then all bets are off, and then it's like we do what we think we can do best is advocate in front of a jury, pick the right jury, do our presentation, and then really find good people that can be fair and find justice. And I think that, and then when you do that, kind of inherently, and maybe the reason why more cases settle is that when you're in the category of law firms that will do that, it will be a trial lawyer and do all those things and try those cases, win, lose, or draw. Because I think we've gone in and, I've lost, big cases, and it happens. But if we're still willing to go and get right back up and get right back on that horse after we just got thrown off, you have a reputation for that. I think that it inherently increases the value for your future clients. So maybe that's why cases.
Yeah, that's something that you and I talk about off the air that probably should just be explicit in the episode. That's part of the motivation here. Yeah. It's not trying for ego, for the bravado of saying I'm a gladiator only. It's to say, every time I step into the arena, my name, my firm becomes more synonymous with risk for insurers. Well, the more synonymous you are with big risk for insurers, the more money they're going to offer you on the next case. Who does that help? Your next client.
Right.
So it's likely to help your client. We feel like our unique value proposition is trying cases. So trying the case is almost certainly going to be the best way to give that particular client the best shot at justice. And then in turn, it's going to parlay and probably help the next one down the line. So yeah, I don't want that to go unsaid. That's a really good point.
Yeah. And we, we've seen it, and I like to, it's like this strange idea that, we're 10 years in, we've been partnered now for, gosh, has it been 5 years? I think it's been 5 years.
2017, I think.
Yeah,
wasn't it April 2017?
It's been 5 years we've been together. We've tried a lot of cases together, and we have seen kind of that matriculation as to what we started as to where we are now in terms of, offers, dealings, results, all the it's all that work is starting to pay off, right? And it's going to.
I feel the same.
Now it's like continuing. It's like the cycle of having a law firm of you got to get the cases in, and then you got to do the pre-suit, then you got to file them, and then you got to litigate them, then you got to go to trial, and then then you have that wheel that just keeps spinning. And so That's why when we talk about motivation, you got to be motivated because that wheel is always spinning. But, recognizing that the inherent value of being a trial lawyer, and then, that and what that brings to every other aspect of the cycle, it helps you because you know what you're looking for in pre-suit. I mean, we're now in our, obviously thanks to Joe Freed, but, in the trucking cases, I'm sending freedom of information requests immediately upon filing, obtaining all the information, doing downloads, stuff in pre-suit because you need it for trial, right? So every aspect of every single case that walks in your door, when they sit down, it's like, what do I need for trial? How am I going to present this? What do I need to look for? And I do that now, right? It's like we have like a rapid response team of all the things we need for every single case. That's why we started getting and securing 911 falls on police crashes, body cam footage from officers, right? That I thought about it, but hadn't thought about it. Now that's routine. We've got forms that we.
Well, it's like controlling the controllables, knowing, of course, that the end goal for us is to end up in a courtroom.
Correct.
If from day one you just were hoping to settle, we wouldn't do any of those things, even if we knew how to do them, probably. Because, I mean, we're not those people, but I can surmise those type of people, they don't give a shit. So it's like the less work I have to do, the less time I'm spending, the more time for me, and maybe one day I'll get a payday. Yeah. And I'll convince the client in some perverse world, no, this is the best outcome. Well, maybe that is the best outcome because you didn't work up the case. So thank God we don't do things that way. Yeah. I really feel good about it.
Yeah, and if you can show your client's injuries through a body cam footage of an officer, I mean, how powerful is that? You're seeing it live time, and we saw, and actually in there, and like obviously we have a case that we're going to be filing soon, and I'm extremely excited about. Excited in the sense that if the insurance company doesn't do the right thing, when we file, it's a trial case. There will be no settlement discussions at all. We're going to go, it's better than Marsha Gonzalez in terms of a carrier case. But in the video, we got the body cam footage. It shows complaints to fire rescue that aren't documented in the fire rescue report. And part of the things is they always say, like, look, there's nothing in this record. They don't say it, blah, blah, blah. That, it's not there, therefore it never happened. But here we are having direct video evidence contradicting the absence of that in a medical record that they would point out. Now we have it. So now it's a discrepancy in the record, which is kind of fits into our stuff. But the idea is that because we know that that's going to be an issue at trial, we can find ways early on to kind of root, like, we're not, I don't want to say route it out. It's not even the word I'm trying to look for. To basically, I don't know what I'm trying to say. Not contradict. I don't know. I'm not an English major, so I speak very colloquial. To basically attack that defense with evidence that you can get at the very beginning and you have to get or it doesn't exist. So I think that, being a trial lawyer, that has helped us. And these methods kind of have changed, I think, the idea that people file lawsuits to settle. And not to say that that's a bad thing. That's just, you want to be able to think in the sense of each case is going to trial. And what do I need to get there? And then if they want to pay me to stop that train, they can do that. And that's how cases settle, not the other way around. So.
I know we're coming up on time, but having just gotten back from firing a couple events of the World Series of Poker, I always say this kind of stuff, but I say because I believe it. There's a lot of similarities between poker and personal injury law. And one of them is when you always have it, when you always get the best hand, you got the nuts in poker, rarely are you getting paid truly what you need, because the other side knows it. So they may give up a little chips and you feel good. You want the pot. Ha, look at this. But it's the people that are always willing to go to the river or make that light call or make that bluff, whatever. They're the ones that when they finally have it again, they get paid piles of chips, or they get paid piles on a verdict because the other side gambles and shoot, do they have it, do they not, or whatever. They're a real risk. And those are the ones in my experience that get paid. And that's how we try and model our business. It's not a gamble. It's just calculated risk assessment by saying, if I prepare this case from trial from day one, every single time I do it against every insurer, they're never going to know which ones were actually like, well, maybe we'd settle if they pay or not. They have to be scared of all of them. And as a result of being scared of all of them, hopefully they pay more for all of them. And that just, helps all of our clients. So
I'm trying to be a cowboy. That's what I want to be. I want to be, they're cowboys. They're reckless over there. That's the idea, but actually we're not. The opposite of that. We're very diligent, hardworking, and calculated. So it may seem
it's an image. It's an image we cultivate, but really beneath the surface, we're nonstop working to crush.
We recognize the power of no, right? You want to, well, other people are taking this money. Great. Well, you're not litigating with other people, and other people may be undervaluing their cases. We're not that firm. We are going to go, and we know our value at trial, and, we see good things happen. And
Yeah, we don't want to be our own limiter, as Joe said a couple of weeks ago, right?
right. Don't be your own limiter and say, look, you can, as much as I don't want to say this, in John Morgan's book, which said you can't teach hungry, he says you need to treat every case like it's a merry-go-round going 6,000 revolutions per minute, and they have to pay you to get off. And that's how you should treat it. And the thing is this, I think that a lot of the defense firms have too many cases, right? As the plaintiffs, I try to have less cases because I can't manage a massive caseload. They can't either. So you can really take advantage of that and push your cases hard because they can't keep up with you because they just got too much work. And when you have too much work, all they're doing is putting out fires, and if they're coming up too fast, eventually.
You got me thinking of that Ozzy Osbourne, was that Black Sabbath, Crazy Train? I just want to play that in the background now. Just have them going nuts.
Right. But eventually, look, if they trying to spend all their time putting out fires, they're not working up this case, and what's going to happen? Eventually that forest is going to burn down, and they're going to be sitting there with a charred event and saying, man, could I have done something different? Maybe. But too many cases will do that. So take advantage of that, So
100%. All right, your depo's coming up, so let's cut this one a little bit short. But thank you, everybody, for tuning in. No guests today. Might be a couple interesting guests coming up we're reaching out to, so we'll keep you on notice of that. But thank you, like always, for joining us, and all our best.
All right, see you guys.
Thanks for checking out the John and Jordan on Justice podcast. If you enjoyed today's content, consider leaving us a review and be sure to subscribe wherever you heard this podcast so you never miss an episode. For more information or to connect with John and Jordan, check out @OnJusticePod on Instagram and Twitter. Or check out Discord for plaintiffattorneys.com to communicate with them and like-minded plaintiff attorneys in a private Discord server. Until next time, this is the John and Jordan on Justice podcast.